I did mention item one,
Louder, bit louder.
item 9 and 10, man.
Yes.
There is another retail bill is pending, man. Retail bill 115 of 2025, man. So with consent of the others, I have to take in consent. This matter will come on 24th of this month, man.
Mr. S.K. Medhi Learned Council for the writ appellants has submitted that another writ bill, writ bill number,
115 of 2025.
Involving similar issues, is to be listed along with these two appeals. On behalf of
Where is it?
Ms. P. Bhattacharya, you are?
State of Mizoram.
Okay, Learned Additional Advocate General for the state of respondent, state of Tripura, Mizoram. And Mr. H. Learned Counsel for the private respondents
Yes, no.
are present and have agreed to the above submission as sought for by the Learned Counsel Board of Parties. List is two appeals along with writ appeal number so and so on 24th.
24th. High level.
Item number
16 hearing letter.
15.
16, 16. I have taken consent of the other side.
On the prayer of Ms. R.B. Bora, you are for the respond number 2. Okay. Learned Legal Aid Counsel for the respond number 2 has made a prayer for adjournment of the appeal with the consent of the Learned Counsel, amicus curiae for the appellant and the Learned Additional Public Prosecutor for the respondent state of Assam. First, the prayer is allowed, please. Appeal. After 2 weeks, on edit 2 weeks by the office.
May please, Your Lordship. Lordship, I have to mention for listing criminal appeal. Matter was pending since 2018. Two appellants is there. One appellant has died in the jail hazard. There are two brothers. One brother has died, and another brother is right now he's in jail, but his heart problem right now is going on. So, my lord, if you
Give it to the court master.
any day. Date will be there.
Please, Lordship, I beg to mention item number 1, Lordship. Lordship, the youngest counsel, due to her illness, she is unable to appear at the court for today, Lordship.
Your name, please.
M. Deka, behalf of G. Bora.
Okay, Ms. M. Deka, Learned Counsel for the appearing on behalf of Ms. G. Bora, Learned Counsel for the appellant. Learned Arguing Counsel for the appellant has made a prayer for adjournment. Whosoever has a prayer is made with the consent of the Learned State Council. The prayer is allowed. Raise the case. After 1 week, on a date to be displayed.
Yes, Lordship.
I beg to item number 2, Lordship. Lordship, this may be taken up some other day, Lordship, because we are ready for 3 and 4, 3, 2, 6.
After vacation, then?
Lordship, actually, in that case also, almost they have completed the.
Maybe after vacation, because we have fixed many matters, not possible. On the prayer of Ms. S.K. Nargis, Learned Counsel for the appellant, lays the case after 2 weeks. Mr. S.C. Gal, Learned Study Counsel, NCB, who is in attendance, has not objected to say prayer.
Daily list for hearing. Items 3 to 5.
Initially, charge was framed under section 21C
Yes,
and 29. But conviction was also passed under section 17C. Did you say anything on it?
on last occasion. Actually, on that day, Lordship, it was kept aside because we have started in some other points.
Yes, when, at what stage we were,
We have argued on Lordship non-compliance of sections, Lordship. Some points I have
what was that order? Some 313, initially, or something like that?
Right.
What was the observation in 313? Something was there.
Yes, in 1 3 13, no answers were given. And subsequently, it was prepared, Lordship, with the answer.
One minute. He passed some order also, the trial court regarding 313.
Yes, yes.
Which,
19, I think,
where is that
Lordship.
order?
Yes. Order I have flag marked in the original record, Lordship.
Original record.
Yes.
Date.
9/6 or 9/4 like that. Mm. Can I see the original recorders? Okay. 2019.
9/4.
2019. Flag it on. Page one again is the statement. Judgment. It is judgment.
Page 85. Page 85 of. Page 50, question number 18. If you're wrong, you better question. Just go like that. Because you- You should see that in there, important. Mr. Kyle, for your noting, we have found that 4 accused, though the predecessor examined the 4 accused persons under section 313, there was nothing for in respect of 3 of them. 1 was complete. Then on 9/4/2019, we found that those were not complete. Then he decided to examine the 3 accused persons, 313, on 22/4/2019. Now come to page 58. Paper book. Page 58.
Yes.
Question number 18. Some he has given some. Right. Now come to page 69. 9. Question number 18. Then you come to page 80. Question number 18. all three of them, whatever, right or wrong, have made some statement. On 22/4/2019, this statement was made. On that very day, judgment was pronounced. Obviously, judgment runs into about 67 pages, total with annexure and all, 67,
67.
right? On that very day. Nowadays, 313 is given prime importance. Just hear me out. Right or wrong, he had made some statement in his defense. An obligation is cast on the court to examine and discard whatever. So delivery of the judgment on the same day and no discussion on these three statements. Question number 18, answers to the, is there anything? That is why I have given you in advance.
I got no.
In advance. Though this point is not argued
Yes.
till now. Because if that is there, something has to be considered. Yes or no, that is a different thing. He may say rightly or wrongly. But he has made some statement before the court. No, because it is fresh in my mind, because I was authoring another judgment, then I have gone through this. And this aspect of the matter has been dealt with by the Supreme Court. That is why I have pointed it out. No, this part also, specific to this part. This, what I am pointing it out. Question number 18.
Even the entire, because,
This is one aspect of the matter.
yes, sir.
So
I
take it.
I'll take it for the line.
Because I know the answer
Not,
now, yesterday. You can carve out something more than that is different.
because also I have, that is.
I would not have noticed because it is fresh in my mind now.
Correct, this is also important. aspect of the matter.
Because it is a direct dialogue between the court and the accused without interference of the prosecution.
Yes.
No, though it is not a statement on oath, but it has some importance. It is a principles of natural justice.
This of, lordship,
And it is a constitutional route now.
Rajan, very much skills I have good. But, no, it is not an evidence, but, some materials maybe one from the statement and that.
Yes. And it could be for the benefit of the prosecution also sometimes.
Because I address on, side of the prosecution. It was appealed by the son of the.
So it is important.
I'll address.
Yes, at what point of time we stopped earlier?
Earlier,
Be specific.
52A, your lordship has read the judgment of Bharat Ambale. Then thereafter.
Ambale, what was there? Because
I group, judgment.
Ambale,
But that was relied in another judgment, lordship observed that in that case, no question was put on them. That aspect of them. And then still lordship, said that
regarding.
because here we find, if I remember correctly, samples were drawn at the spot.
Yes. And all the.
Inventory was prepared. inventory was seen, not certified.
Yes,
That is one. But the original bags were
produced.
placed before the court during the time of evidence. Now, 52A, within 52A, there one is certification of the inventory. Second is photographs. But photographs is a substitute of non-production of the original contraband. Certification of, there is a 52A
Yes,
subsection 2, I think B something, photographs. Is it not?
Lordship.
Don't go to subsection 4 first. First understand subsection 2.
Two,
Don't jump to
Yes.
subsection 4.
yes. A, B, C,
One is inventory, certified.
yes.
2 is list of samples or photographs.
Photographs,
And 3 is
allowing to draw the representative samples.
3.
C is allowing to draw the
Ah.
representative samples.
Now,
One list of samples shown
ah,
in C.
and C. So, photograph on the day when they were produced, whether those contrabands were produced before the court. So, it could be that if you go to subsection 4, notwithstanding anything,
Yes.
so if the, I think in your case I have held, if the original is not produced, the certified photographs. No. If both are not produced, then no, the thing itself is not produced. Here, and the first one is inventory. It was seen. Second one is the photographs. If it is certified by magistrate, original need not be produced. Original contraband. But here, instead of photograph, original was produced before the court. Original contraband in bags. And third one, this list of sample. 7 perhaps.
C. Is C six?
7 samples.
Yes.
What happened about that? How it was supposed Ambale somewhere said the samples can be drawn at the spot also. Where is it? Ambale?
Ambale exactly not that.
Ambale has diluted the Mandilam and the,
Huh?
No, not diluted.
in my submission. Ambale has changed the entire scenario of section 52. So she comes to paragraph 6. Legislative history and response of section 52 of the invitation.
This is a two judge decision.
Yes. It's a,
Many,
All judgments were of.
then maybe some, it will be held par incuriam. It could be, because
That judgment has been taken into consideration.
things,
that was not overruled by this judgment.
All these judgments were taken into consideration by consider. Tacit judgment also.
which judgment?
Tacit. Although it was related to bail losses, but observation they have made.
No, about sample, here, let us see this particular thing. We will not go. One minute.
That judgment is required to be considered by
Summarize.
paragraph 6.
Come to paragraph 6(1).
Yes, legislative history and scope of 52A of the application.
Six. Those are the- Nothing.
Paragraph three is also, the question was framed by Robert before. The only contention raised before us.
Let me read.
Sure.
So it says that ultimately it says whatever discussion is made, non-compliance with the procedural requirement of section 52A does not necessarily vitiate the trial or warrant an automatic acquittal. The courts have consistently held that procedural lapses must be viewed in the context of the overall evidence. If the prosecution can otherwise establish the chain of custody, corroborate the seizure with credible testimony, prove its case beyond reasonable doubt, mere non-compliance with section 52A may not be fatal. The emphasis must be on the substantive justice rather than procedural technicalities, and keeping in mind that the salutary objective of the NDPS Act is to curb the menace of drug trafficking. So, what does this sample, the sample what was drawn at the spot, seven of them. So how this to be, what is the root of the sample? How this sample is to reach FSL? Please. This point you take note. Yes. Because every case presents its own problem,
Yes,
own issues.
yes.
Because 52A subsection 2 says it is certification, not seen.
That,
I have held,
that has been distinguished in your lordship's judgment.
I have held.
Yes.
Seen and certificate.
It is before Paula's case. Of course, before a Paula's case.
No, Ambala is not. Ambala has not discussed that.
Yes, no,
That-
this was not. It was-
No, we have distinguished. That point is not dealt with.
Subsequently, it was.
Ambala has not.
Discuss that thing, lordship, whether it's certification or sin, that has not been distinguished, lordship. It is distinguished by your lordship.
Seen and certified are two different things.
Yes.
Yes, sir. It's
Certified means he takes the responsibility.
Exactly.
I said that responsibility. That-
Very strict. That yes, I have seen, verified and certified. So inventory, if it's certified, then becomes a primary evidence. Right. That becomes a primary evidence. No doubt about it.
Yes, sir.
But here is a case, inventory is not certified, seen,
Was seen by
Seen.
the, yes.
right?
Yes, yes,
That is one part.
Yeah.
Second, photographs
Not taken.
not.
not taken and so not certified. But here is a case, original contraband was produced.
List of sample also.
What is about the list of samples? Because that is the most important, because the whole case is,
based on-
conviction is based on the results of the
FSL.
samples.
Yes,
So how it has traveled?
yes,
Yes. It was spot recovery,
spot recovery.
samples drawn the spot.
Yes.
Now here, no independent witnesses.
Mm,
Examine.
This is were there, but they were not examined.
No,
by the court.
examine, I say.
Not exact.
Yes, correct. I guess,
So that is a slight,
Yes, no doubt.
Yes, yes,
small gap opening is there.
Yes.
How it is to be closed or to be open,
that is to be
looked into.
looked into by Lordship and that materials available in the record.
Huh?
My lord, for that lordship, kindly have a look at the not standing order 1/10.
No, in this case, how the samples have traveled
Sam-
and
sam-
reached FSL, please
With lordship.
apprise this.
Here in this.
Where is the initial recovery of samples?
Yes. The PW3 has stated. these
No,
things.
no, document.
Document, lordship will find at the receipt, go down receipt. At
The
page number,
spot recovery. Some
Spot.
Panchnama or some-
Panstama is there,
please,
lordship. Panstama prepared lordship at the spot. Lordship. Page number. Hmm? Huh? Page number 178.
Sargam seizure, 175.
Pasnama, it's a type copy of.
Let me see 175 first.
Season.
Yes, let us see Panchnama.
Yes.
Let us read.
From the past news.
Hmm.
After getting information from a reliable source, Bureau on 6/5/2016 at 17:30 hours that two persons, namely Abdul Kalam and Mujibur Rahman, will be going to deliver a consignment of morphine and opium to two other persons, namely Saurabh Khan and Ram Milan, near Indira Gandhi Stadium, Holkozai, Guwahati at 7 a.m. on 7/5/2016. And after reducing the same into writing, it was informed to Mrs. Tulika Moral, Superintendent NCB Guwahati Zonal Unit. After that, a team consisting of Sri Suresh Kumar Singh, Sri Anjani Kumar, Sri Pawan Besane, Sri Sarup Sanda, and Sujit Chil Sharma, Sri Santanu Guha, Bipin Kumar, Sandeep Kumar, and Vikram Singh, and Bhupendra Yadav was constituted. After getting orders, the said team with the informer moved from NCB Guwahati office at 6 hours from 7/5/2016. After reaching near Indira Gandhi Stadium, Sorosozai, the NCB team approached two persons who were walking there. On asking, they conveyed their names as Dimbeswar Basumatari, Sadgaon, Guwahati, and Nilan Raskwa of Beharbari near AG office, Guwahati, and told them about the information available with the team, and introduction of the team members from NCB Guwahati was given to them, and requested both of them to be independent witnesses in the process of search and seizure, if any. When NCB team, along with the informer and independent witnesses, reached near the spot, a white Scorpio bearing number was seen parked on the service road at about 6:30 hours. One truck having numbers on the reached near the Scorpio. Just after it, two persons from the Scorpio came out and went near the trucks. So then two persons came out of the truck, and these four persons discussed something for about 1 minute. The team was indicated by the informer, and it was told that these are the four persons who are trafficking the opium and morphine. After that, one person entered the cabin of the truck bearing number 7 and handed over a few polythene to the persons who were standing near the truck. The NCB team, along with two independent witnesses, rushed towards the said truck and Scorpio. When the NCB team, along with the independent witnesses, reached near the said vehicles, all the four persons were standing near the truck with polythenes in their hands. Introduction of the team independent witnesses was given to them. They were also told about the information available with the team. On asking the four persons, they identified themselves as details of the persons. Before conducting search of the four suspected persons, namely so and their belongings, provisions of Section 100 CRPC were followed. On opening the plastic bags carried in both hands, Mr. Saurabh Khan, dark brown color sticky material was found, packed into packets wrapped by brown color sellotape and kept in white polythenes. A small quantity of dark brown color sticky material was taken out from both the packets and tested with the help of drug detection kit brought by the NCB team, and both materials gave a positive color for opium. Both white plastic bags were marked as C1 and C2, and packets containing dark brown color sticky material were marked as P1 and P2. On weighing with the help of digital weighing machine brought by NCB team in presence of two independent witnesses and the four suspects, and weight P1 and P2 was found to be 10.12 kg gross and 10.14 kg gross respectively. Further, suspected opium was seized and the NCB team in the presence of two independent witnesses and the four accused drew the sample in duplicate of 24 gram each and marked as S1 and D1 and S2 and D2 respectively. All four samples were duly packed in polythene and then kept inside the inside as envelope. All the samples and seized dark brown color sticky material suspected to be opium was sealed with brass seal number 1 and properly labeled and signature of independent witnesses. All four accused person and seizing officer was also taken. The polythene bag carried by Muhammad Mujibur Rahman was searched. On opening the plastic bag carried by Mujibur Rahman, dark brown color sticky material was found packed in one packet wrapped by brown cellotape and kept in white polythene. A small quantity of dark brown color sticky material was taken out from the packet and tested with the help of drug detection kit brought by the NCB team, and the material gave positive color for opium. This white plastic bag was marked as C3 and packet containing dark brown color sticky material was marked as P3. On weighing with the help of digital weighing machine brought by NCB team in presence of two independent witnesses and the four suspects, and weight of P3 was found to be 10.11 kg gross. Further suspected opium was seized. Then NCB team in the presence of two independent witnesses and the four accused drew one sample in duplicate of 24 gram each and marked as S3 and D3. Both samples were duly packed in polythene and then kept in inside an envelope. All samples and seized dark brown color sticky material suspected to be opium was sealed with brass seal number 1 and properly labeled and signature of independent witness. All four accused and the seizing officer was also taken. The polythene bag carried by Ram Milan were searched. On opening the plastic bags carried in both hands by Ram Milan, dark brown color sticky material was found packed in two packets wrapped by brown color sellotape and kept in white polythene. A small quantity of dark brown color sticky material was taken out from both the packets and tested with the help of drug detection kit brought by the NCB team, and both materials gave a positive color for opium. Both white plastic bags were marked as C4, C5 and packet containing the dark brown color sticky material were marked as P4 and P5. On weighing with the help of digital weighing machine brought by NCB team in presence of two independent witnesses and four suspect, and weight of P4 and P5 was found to be 10.16. Further suspected opium was seized. Then NCB team in presence of two independent witnesses and the four accused drew one sample in duplicate of 24 gram each and marked as S4 and D4 and S5 and D5 respectively. All four samples were duly packed in polythene and then kept inside an envelope. All the samples and seized dark brown color sticky material suspected opium was sealed with NCB brass seal number 1 and properly labeled and signature of independent witnesses, and all four accused and the seizing officer was also taken. The polythene bags carried by Muhammad Abdul Kalam were searched. On opening one of the plastic bags carried by Muhammad Abdul Kalam, dark brown color sticky material was found packed in one packet wrapped by brown color cellotape and kept in white polythene. A small quantity of dark brown color sticky material was taken out from the said packet and tested with the help of drug detection kit brought by the NCB team, and materials gave a positive color for opium. The white plastic bags was marked as C6 and packet containing dark brown color sticky material was marked as P6 on weighing with the help of digital weighing machine brought by the NCB team in presence of two independent witnesses and four suspects, and the weight of P6 was found to be 3.878 kg gross. Further, suspected opium was seized, and NCB team in presence of the two independent witnesses and four accused drew one sample in duplicate of 24 gram each and marked as S6 and B6. Both samples were duly packed in polythene and then kept inside an envelope. Both samples and seized dark brown color sticky material suspected to be opium was sealed with NCB brush seal number 1 and properly labeled, and signature of the independent witnesses of all four accused and seizing officer was also taken. On opening the second plastic bag carried by Abdul Kalam, uh, brown color powder was found in one packet wrapped by brown color sellotape and kept in white polythene. A small quantity of brown color powder was taken out from the said packet and tested with the help of dark detection kit brought by the NCB team, and material gave a positive color for morphine. Then white plastic bag was marked as C7 and packet containing dark brown color powder was marked as P7 on weighing with the help of digital weighing machine brought by NCB team in presence of two independent witnesses and four suspects, and weight of P7 was found to be 2.06060 kg gross. Further, suspected morphine was seized. Then NCB team in presence of two independent witnesses and four accused persons drew one sample in duplicate of 5 gram each and marked as S7 and D7. Both samples were duly packed in polythene and then kept inside an envelope. Both samples and seized dark brown color powder suspected to be morphine was sealed with the brush seal number 1 and properly labeled and signature of the independent witnesses. All four accused and the seizing officer was also taken. Mohammad Abdul Kalam, Saurabh Khan, Mojibur Rahman, and Ram Milan were issued notice under Section 50 by Sri Pawan Baisana Intelligence Officer NCB Guwahati in written. They were told that their personal search has to be carried out. They were told verbally and in writing that as per provision of Section 50 of NDPS Act, it is their legal right that their personal search can be carried out in front of the nearest gazetted officer or magistrate if they wish so. In written response of the notice under Section 50 of NDPS Act, they told that their personal search should be conducted by the available team members only as they have full faith in the team, and they further told that they do not want that their personal search be carried out in presence of magistrate or any gazetted officer. Their lawful search was conducted in presence of two independent witnesses, and during their personal search, no contraband was recovered from their body. During the personal search, Muhammad Abdul Kalam, one PAN card to Muhammad Abdul Kalam having numbers also were recovered. During personal search of Muhammad Saurabh Khan, PAN card issued to Muhammad Saurabh Khan having numbers also were recovered. During personal search, Ram Milan, PAN card issued to Ram Milan were recovered. During personal search of Mojibur Rahman, copy of document related to the ownership of truck and INR rupees 2000 were recovered. All the recovered documents during personal search of all four persons were kept inside an envelope, and money was kept in another envelope duly marked and sealed by NCB brush seal number 1 and properly labeled and signature of independent witnesses. All four accused and seizing officer was also taken. Both vehicles, that is truck and a Scorpio, were searched. On searching the Scorpio, it was found that a special cavity has been made in vehicle numbers. And so on inquiry, Saurabh Khan admitted that vehicle numbers are registered in his name. He further told that he had made this special cavity for trafficking of drugs. Scorpio was seized. On inquiry, it was told by Mojibur Rahman is registered in his name. He further told that he had brought said consignment of opium and morphine from Imphal in this truck. Bearing number, the truck was seized photocopies of insurance premium slip of truck numbers only issued by United in India Insurance Company Limited and public areas permit issued by Transport Authority Thawbal against vehicle numbers and also were also seized. On inquiry, all 4 persons admitted their involvement in trafficking of drugs, and they also revealed that they have been doing illegal trafficking of morphine and opium for the last many years for monetary benefit. Thereafter, on reasonable belief that an offense has been committed under section so and so and so, and the entire consignment believed to be opium and morphine was seized under section 43 of NDPS Act. The search cum seizure list and a customer were prepared on spot. The seizure process was completed at about 12 hours on 7/5/2016 without causing any injury and mental pressure and damage to any property. This was the first document prepared at the spot. And samples collected there, and thereafter it was seizure list minus sample. It is not mentioned in the seizure list regarding the samples, but receipt to receipt.
What is the list of material exhibits
Lordship,
before the court?
it is in the
Judgment,
disposition of
judgment.
PW3
Judgment.
judgment.
Last page. And
Yes. Judgment. It is been. Hundred, Lordship will find at page 109. Almost material exhibit 101. And all the list, Lordship will find at page 152, page number 152. Material exhibits.
Where are the defense witnesses?
Defense witnesses also will find at
Hmm?
page 44.
Page
44.
44.
Yes.
These witnesses were brought when?
After, uh, after the T13, after the statement recorded T13 mile. First,
First.
Second of
First.
February 2000.
Uh. And where he discussed this DW
in judgment.
in judgment.
Mhm. 131, paragraph
131.
These witnesses are for whom?
Or
Sora.
Khan.
Ms. Nargis, what you can find from Panchnama seizure list that 7 bags of different weights, 6 of them
Okay.
suspected to be containing opium, 1 suspected to be containing morphine was seized. And the trial court has discarded the T of Illibai of Sorakta. Then at that time, as per the Panchnama,
Page 178.
as per the Panchnama, 4 persons from all 4 bags were seized. And those were marked, plastic bags were marked
C1 and
C1 to C7.
C7. Material P1 to
And packets were marked as P1 to P7.
P7.
And samples were drawn 24 gram each from 1 to 6 and two samples,
S1,
S1 and D1, like that, S1 up to from S1 to S7. For morphine, it is S7
yes,
and D7. So this is C1 to C7, P1 to P7, S1 to S7, D1 to D7. Panchnama prepared. Accused person's signature were taken. Independent witnesses' signatures were taken. IO or seizure officer may give his signature. So means that 7 signatures were there. Samples. Then after that, it was deposited in the godown. Then on the next day, all those were taken out by the IO or
Seizing of-
PW3 to the court. An inventory was prepared. Details were incorporated. Right? And that inventory is purportedly under section 52A, 221. Evidently, there was no application under subsection 3 of 52A,
yes,
but it was forwarded under section 52A, inventory. So, if there is no application under subsection 3, magistrate does not certify. So, magistrate had seen whatever is there, page 2022, 224, you see,
There is-
2025, right? P1 to P6, P7, weight with sample, weight without sample, sample, right?
yes,
These are there. Magistrate has seen it. 224. Have you seen it?
yes,
Right. Gross weight, everything was there. The original from gross.
yes,
And it is mentioned that deep brown color powder
powder,
believed to be opium
yes,
and deep brown color powder believed to be
morphine,
morphine. Plastic bag, so and so, so and so. It is there. So after producing in the court, again deposited in the same day, 8/5. Then on 9/5, all 7
samples,
samples, S1 to S7, were forwarded, right? Now let us see who got it. The expert,
expert PW1,
PW1.
PW1,
He got it on 9/5,
yes,
on 9/5.
Yes.
And he got S1 to S7.
Mm.
Right.
yes,
Now on 9/5 itself, let us see again the Panchnama once more. Where is that Panchnama?
117,
Huh?
178,
178. Dark brown color,
sticky substance.
sticky.
Yes,
Now come to page 3,
yes,
pasty substance.
yes,
Pasty, sticky, it
Same.
appears to be the
same,
same. Now, what was opening after you tried for opening of the bags? What was there?
Because in
Let
the
us see.
opening also sticky.
You opened the bags before the
Yes.
court.
That is also dark.
Where is that?
That is lordship in the deposition of PW3.
3,
Yes, the last in the
cross.
cross part.
Magistrate recorded something.
Yes, yes.
Oh, sorry, the
Page
special
33.
code.
Yes.
Huh.
Page 33.
Good.
Page 33.
Page.
33.
Still marking and open coat both sides. Sticky.
Yes.
So sticky. I forget the 174. Once more.
Sticky or
170, you said?
eight, eight.
Huh?
Yes, eight.
178.
Eight.
Sticky.
Yes.
This sticky at the time of seizure,
Serial.
it says sticky. Samples were drawn. Samples should definitely be sticky. Right? Then after that, it was deposited in the court on the same day, sorry, Gudam,
Go down.
taken out in the morning next day for court, right? Then thereafter, in the
220. Page 220.
sorry, this 52A
Yeah, page 220.
page
221.
221.
Yes. And the main relevant portion is 224.
Huh. Here only it is mentioned as powder,
Yes.
right?
Yes.
This is your bone of contention. And when open in the court,
It was
again
very sticky.
sticky. The bags.
That's
Ponsnama says sticky,
customer is
right? When FSL expert got it on 9/5, it was pasty,
tasty. Yes. Yes.
except that powder kind of mentioned
Yes.
in the 52A inventory.
Yes.
Everywhere it is sticky, pasty, whatever. And that status did not change when you open the bag before the court. And magistrate also mentioned, page 30,
Okay.
but 33, the special session judge or special court,
Yes.
that brown sticky substance, dark brown. Now, one of your contention is powder. Second is deep brown, dark brown. But so far,
Other
if you
document.
go Ambale, paragraph 29 to 33 or up to 33, that if there is not substantial, then it is okay. But samples were not certified. That is the only one. Because here, all the bags were produced. And since there was no application, so there was no certification. Because magistrate can certify only if there is an application under subsection 3.
Yes.
Is it not? Now what would happen? Neither Ambale, neither Mongilal, everything. It is not answered. There has to be an application.
Yes.
Then only certification. Right? And thereafter only those certificates can be used as primary evidence under subsection 4 of section 52A. This is the position. right? Second is independent witnesses. That is one.
That is to
Right.
support their case.
To support their case. That is non-examination.
Yes,
So far, this sticky and all this thing, we don't find pasty, sticky,
lordship.
nothing, deep brown, dark brown.
And the powder.
Only thing is how the samples, whether samples drawn at the spot of recovery, produced before the court, but without any certification, it was sent to the FSL. FSL report tested positive for opium and
Morphine.
morphine. And this contraband also in the bags, ultimately it is same thing, pasty. When it was open at your insistence. It was your insistence for which the bags were open, right? So this is the limited spare. I have understood going by everything. This is the limited spare. That 313 is there, right? Which I have asked. So far, pasty, sticky, this thing, only thing is sample. Because original contraband is produced, so original contraband is produced with seal and signature of the accused persons and seizure officer and independent witnesses. Now independent witnesses did not come. Whatever. These are the limited spare in this case. If I have understood correctly, read with section 52A, you have to make submission. And with all these samples, this Gudam seal, whatever you say, 52, section 52, 53, 55. Limited area is that.
Yes,
And ultimately, if it is, say, appeal is not allowed, suppose it is 32B,
yes,
right?
Yes.
So
Yes, yes.
these are the
yes.
area. After going through, yes, anything.
And my lord, before starting my plea, I would like to submit I want to add one thing, lordship. Rightly or wrongly, they have placed inventory before the court, before the magistrate. In that document, he has stated that deep brown color powdery substance he produced before the court. It was not opened before the court.
I'll be over.
My
This
lord,
is too much,
to that-
going far too much.
lordship, to that
You
regard,
say about
lordship,
samples,
Lordship,
whether
the
it
sample also not,
was the way the samples ultimately reached from the place of recovery
that,
to the FSL,
that is I would like to,
whether in that road
lord,
you
my
are
lord.
traveling to Guwahati to Nagaon.
lordship,
So
Lord.
place of recovery to place
FSL.
of examination,
Lord.
FSL.
Lordship,
Right.
to that regard,
Whether in this route there is something prejudicial to the accused which has caused miscarriage of justice.
lordship, to that regard, I would like to place
But
the,
don't go here and there.
no, I'm not, I'm not going here and there, lordship. Only to that regard, lordship, I would like to place this notification 1/89. Here specifically mentioned the duty.
Because 1/89 situation has been diluted to an extent by Ambale.
But lordship, it is
I have
clarified in
read,
Ambala.
I have read
Lordship, have gone once more again, lordship,
52, if you read from 30 onwards,
lordship,
up to
but-
33,
lordship.
then somewhat, if it inspires the confidence of the court,
Yes,
substantial compliance, all these things have been mentioned.
lordship.
That is why I'm saying where the miscarriage of justice has
I want to
occurred.
explain that one only, lordship. It is the duty, after depositing the samples and seized contraband to the officer in charge or the godown in charge, his duty stop there. The duty of the seizing officer stop there as per 1/89, lordship.
I have mentioned, Ms. Nargis, please, I have mentioned also that the seal packets contain signatures of all the four accused persons. Please mention, please keep in mind,
Your Lordship,
right? Did you dispute anywhere that point? Be mindful of that fact.
yes,
Court takes also notice of that,
yes,
right?
of course.
Did you challenge or question about that aspect anywhere? We have to see the whole picture, right? Whether did you challenge that aspect?
No, we could have.
That these are our not signatures, are not our signatures, whether signatures were there, have you questioned?
Signature was not.
Your.
My one, the signature was not exhibited during the trial, Lordship. Only mentioned that signatures were there. He has stated. But Lordship, before that, after keeping the contraband in the godown, Lordship, it is the duty of the PW2 officer in charge to prepare the inventory.
You have cross-examined extensively, come to page 12 also. Come to page 12 onwards.
Yes.
Matt EXT1, he makes a statement. It contained the signature. Yes, order sheet.
Order sheet, Lordship, 9/2018.
9.
2018. Then
9, 2.
after giving the last chance, lordship, as to why the searching officer could not bring the person to the court. That too even regarding Lula Brasford. For other, he has not, the court also not express any view, and the prosecution also did not mention anything as to why they could not bring this person before the court. Whether really they were there at the, this person were Pixius or something else, that is not there much.
Did you see process server report?
Person,
Did you see process server report?
I have not seen it. I have not seen.
Then you are making that submission to, for us to look into that.
No, I'm sorry.
Hmm? See?
I'll see.
So later.
It's from. It's missing.
Yes. Yes.
My lord, in this file, I have not found, regarding the process server issue. No steps has been taken by, as per the Haziras and all, no steps has been taken by the prosecution teams.
Are you making a responsible statement?
My lord, in this, I have not.
Are you making a responsible statement? With all responsibility at your command, then we'll look into it. You are the defense counsel, I think in the trial.
I'm not only the defense lordship, some other persons also.
But you are one of them,
Yes, yes.
it looks like. Your name is there, page 87 in the judgment of the trial court. So, there was submission you make with all responsibility.
Some more counsels were there.
You are one of them.
Yes, boss.
So make submission with all responsibility.
My lord, can I check other two records?
It should be checked at the time of, before starting of hearing.
But I have gone through the record lordship earlier occasion.
Otherwise, why the judge will say that there is a report that the address, there was nobody found in the address.
After that lordship, again someone issued. After that, again someone issued lordship.
Last search
Last chance.
was given.
Last chance was given to the soliciting officer. To, if there is any person, they, at the time of person seizure, that person should be.
Because law is also that just because independent witnesses were not examined, the investigating officer or police officials or whatever, their testimony cannot be looked with an eye of suspicion.
Exactly, lordship.
Law is also that.
Lordship.
So each case has to be decided on its own facts. And you have also taken so many times for defense witness. Court has also reported that you have
That is
dragged the matter for defense witnesses 8-9 months. You have dragged the issue. No defense witness entered. All these are there also. If this goes one way, it goes also other way, double-edged.
But lordship, it is a prosecution, plus they adduce the evidence lordship.
That within that sphere, you say, independent witness not examined. Court has recorded paragraph 70. What do you say about that? What does it reflects? Make submission.
But in, yeah, the punishment under this act is very stringent. So lordship, it is.
That I know.
May I please, sir?
Yes, madam.
Item number 13, lordship. Item number 13, hearing matter.
Hmm.
Make after vacation. Opposite party, I have informed he is not there also, Mr. Khan is not.
Okay. Ms. S. Kanangul and counsel for the appellant. comma, with due information to the learned counsel for the respondent, comma, has made a paper adjournment of the appeal. Full stop, as paid for by Ms. Karingo, list is immediately after the ensuing summer vacation, point, summer vacation.
Supplementary list for orders, item 15.
Oh. Timely. Yes, Mr. Bhattacharya. And this will take time.
Take time.
It will take time.
It will,
So I'll not make you wait.
next on July 17th. After the
Okay. Which one? Item
8.
28. Item
8.
8. 8. Okay. Oh, Miss Bhuya is there. Okay, Mr. K. Bhattacharya, learning counsel for the appellant, and Miss B. Bhuya, and senior counsel and amicus curiae for the respondent are present. So, as for by the learning counsel for the parties, there is the case on 17th July.
Left.
Yes, anything to add?
Nothing.
Some submission. I have to record vehemently opposed or what? Some.
Not to
I have
say
to-
when the circumstances called down by the learned trial court, that.
That paragraph,
Paragraph 40 of the judgment at page 207.
paragraph 4207. Is section 33. And this is the chain of circumstance that I have found one more.
Yes, well.
Section 33. I have found one more.
Section 33.
Section 33 of the evidence. That day I have seen. Paragraph 46. Chittaranjan Dasgupta.
Yes.
But at
He died.
point
He died.
He died, madam. His statement was recorded.
So how section 33 comes in?
Oh, shit.
Because he is the only person. Where is his statement?
That is exhibited 164, madam.
164. Why he was not brought? He died.
He expired.
He expired.
230.
But he has implicated other accused, not me. There's
239. Where is the evidence that he died?
that.
In the judgment?
I owe my, I owe most probably.
Ayo.
He told 21.
Citron, okay, died. So 33 evidence,
33.
33,
33.
Section
3.
30.
No, no. He is not an accused, that is for a co-accused.
Yes, no, as regards the discovery, but it was already done, discovered.
Okay, go on. Judgment. At one place, we will mention Sanjeev as A1. Thereafter, we will mention him as A1 only,
Yes.
right? And these two appellants are categorized as A1, A2 and A3.
A2 and A3.
Ah. Then take your seat and,
And there's one judgment, any just for
yes, yes, sure, sure.
which is Justice Gavai judgment, my lord, regarding the, they want to say about the, regarding circumstantial evidence, my lord.
Hmm.
The 5 principle has to be followed, my lord.
Ponsosil, Sarda Bidisan.
Sada will, that again has been explained, my lord. This will.
The present criminal appeals under section 415. This is the first appeal under section BNSS for me. নামটো কি আছে? ভারতীয় নাগরিক
ভারতীয় নাগরিক
সুরক্ষা
সানিতা
সংহিতা 2023 is directed against a judgment dated 12/12/2024 and an order on sentence dated 19/12/2024 passed by the Court of Learned Session Judge Soraideo at Sunari in sessions within bracket as this C capital. Case number, page 146 on us. 12/2014. Post up. By the judgment and order on sentence, comma. No, I can go. Three accused persons stood the trial in sessions SC case number 12/2014. And they were one, Sanjeev Paul, within bracket, hereinafter referred to as A-1, comma, at basis, comma, for easy reference. Two, Sahabuddin Ahmed, alias June Ahmed, within bracket A2. And three, Mohammad Rekibuddin Ahmed, alias Haiti Ahmed, A3. Full stop. By the judgment and order on sentence, comma, all the three accused persons have been convicted for the offense under section 302, comma, Indian Penal Code, read with section 34 IPC. So they have also been convicted for the offense under section 201 IPC, read with section 34 IPC. Post up. The two accused appellants hearing have been sentenced. After hearing the convicted accused persons under section 235 on sentence under section 235 within bracket 2 CRPC, the two accused appellants have been sentenced to undergo imprisonment for life and to pay a fine of rupees 10,000 each, comma, in default of payment of fine, comma, to undergo simple imprisonment for another 3 months each. Under section 302 IPC, read with section 34 IPC. Post up. It is observed that out of the period of sentence, comma, 10 years shall be rigorous imprisonment and rest of the sentence shall be simple imprisonment. Full stop. For the offense under section 201 IPC read with section 34 IPC, comma, the two accused appellants have been sentenced to undergo imprisonment for 3 years. Full stop. It has been ordered that both the sentences shall run concurrently. Full stop. We have heard Mr. P. Kotoki, learned counsel for the two accused appellants, and Ms. B. Bhuyan, at senior counsel in additional and public prosecutor. Assisted by Ms. R. Das, learned counsel for the respondent state. Full stop. Mr. Kotoki, learned counsel appearing for the appellants, has submitted that in order to bring home the charges against the appellants and the other accused, comma, A1, appellants, comma, A2 and A3, and the other accused, comma, A1, comma, the prosecution side prosecution side, you have to do. Examined 21 number of witnesses, apart from one witness as and exhibited (17) number of documents. Full stop. It will be apparent from the prosecution evidence, comma, the case of the prosecution is based on circumstantial evidence. Full stop. The trial court packet. The learned trial court had comma, in paragraph 40 of the impugned judgment, comma, enumerated a number of circumstances which, comma, according to it, comma, had been established by the prosecution. Full stop. Established by the prosecution to hold that the chain of circumstances was complete to bring home the charges against the accused appellants. Full stop. The learned trial court has also placed reliance in a statement of a person, exhibited as Exhibit P-8, to hold that holding that the statement recorded under section 164 CRPC is admissible in evidence. Full stop. Mr. Kotoki has submitted that the learned trial court erred in holding that the circumstances indicated in paragraph 14 of the judgment, established as established. Pardon me, wrong. Established. Full stop. He has submitted that conclusion drawn by the trial court was based on inadmissible evidence. Full stop. Moreover, the statement of the person recorded under section 164 CRPC cannot be admissible on the premise that that person had died during the pendency of a trial. Full stop. The rule of evidence contained in section 33 of the Evidence Act requires that the adverse party should have the right and opportunity to cross-examine such a witness. Full stop. It is his further submission that the learned trial court has accepted the testimony of a number of witnesses in clear ignorance of the prescription contained in section 25 and 26 of the Evidence Act. Mr. Dasgupta, I don't think you should wait. I'll relieve. This court likes leave. So, anything else?
No. And my lord, that is, oh, that's 24, 25, that's the mainly actually. We are implicated by because of the co-existence.
Not 25, 26.
Yes, sir.
25, 26. There was no discovery on the basis of any disclosure statement. And as such, Section 27 of the Evidence Act is clearly not applicable in the case in hand. This is all? Yes, Ms. Bhuyan, what to record? Tell me something so that I can record. Ms. Bhuyan and additional public prosecutor appearing for the state has supported the judgment and order of conviction and sentence passed by the Learned Trial Court. Full stop.
The circumstances, this persons hired a vehicle
Hmm.
from PW 15. Roshan, and there is a extrajudicial confession made to one of the witnesses that he was declared hostile.
There is evidence on record that the vehicle where the deceased was taken prior to her murder was seized during the investigation.
And PW 9 has deposed, he is the son of the deceased. Mother told she had gone to Guwahati with Sanjeev Kaur.
And the informant, the son of the deceased, had testified about the fact that the deceased and the accused, A1, were last seen together,
And
leaving for Guwahati.
gone out of the residence together. And can the contents of the FIR be discussed according to Asulas?
First of-
She left
Ah.
with Sanjeev Kaur.
And the fact that the deceased and the accused, A1, had a relationship, was in a relationship, is borne out from the evidence on record. And appellant's hearing were roped in by the said accused person, A1, in order to kill the deceased. Full stop. In the above, Ms. Bhuyan submitted that in the above obtaining fact situation, no interference is called for. And present appeal deserves to be dismissed. Full stop. Para. The first information report aimed to be lodged before the officer in charge, Ponneri Police Station, by one Ananto Goala on 4/9/2008. So the informant Ananta Goala in the affair had inter alia alleged that on 23/8/2008, his mother, Junaki Koala, left their home in order to go to the house of the accused, A1, a resident of Ward number 9, Punari Nagar. Full stop. The informant mentioned that while leaving, his mother informed him that she would go to Guwahati with A1 for some work. Full stop. It was mentioned that Junaki Goala had been working as a housemate in the house of A1 for a period of time. And it was well known among the neighbors that Junaki Goala had a relationship with A1. Most of the informant further mentioned that when the existing relationship between the two came to light, A1 cajoled Junaki Goala to keep the affair hidden. In the affair, it was further mentioned that when the informant, on 3/9/2008, went to meet A1 to ask about his mother, A1 abused him and drove him away. Full stop. The informant further mentioned that when he came to know he came to know that his mother confided before one Sitaranjan Dasgupta, within bracket, not a witness, another, a senior resident of their village, that A1 had been trying to kill her. Full stop. Stating so, the informant suspected that A1 had killed his mother somewhere. Full stop. In the affair, a description of Junaki Gwala was made. It was specifically mentioned that the name of the accused, A1, was written in black ink on one hand and Sri, quote unquote, Sri Krishna was written on the other hand. On the basis of, on receipt of the affair, the officer in charge, Punari Police Station, registered the same as Punari Police Station case number 194 of 2008 for the under sections, under section 302 and section 201 of the Indian Penal Code on 4/9/2008, and entrusted the investigation to one Abidur Rahman, within bracket PW 21, to take up the investigation of the case. Sorry, sir. During the course of investigation, Commander IOPW1 made a number of seizures and by seizure list, by preparing seizure list and recorded the statements of witnesses under section 161 CRPC. Post hoc. The IO also recorded the statement of Chittaranjan Dasgupta under section 164 CRPC. On 30/10/2008. Post hoc. After completing investigation into the case, comma, the IOPW 21. But he did not highlight it. Question. After investigation, a search it under section 173 to CIPC. Right, search it number 204/2008 came to be submitted, came to be late on 26/12/2008, finding a prima facie case against the three accused persons, comma, mentioned here in above, comma, for committing the offenses under section 302, section 302 and section 201, IPC, read with section 34 IPC. Post hoc. Para. It is relevant to mention that about few preceding events, which preceded the institution of the FIR on 4/9/2008. Post hoc. The preceding events, the events which preceded the institution of the FIR can be noticed from the testimony of the IO who deposed as BW 21. Page 51. Itu para agon. In order to bring home the charges against the accused persons, comma, index লিখি দিব। During the course of the trial, the prosecution side examined the following prosecution witnesses and the court examined the following person as court witness only in index number 21 of the CW1. Three. On 29, sequence of events, no? And from PW 21, no? On 29/8/2008, no, at about 7 AM on 29/8/2008, comma. Oren Tati, within bracket PW3, comma, a resident of Ido Pukuri. And the then VDP secretary submitted an application before the Sonari police station stating that one dead body of a female was found in a drain within bracket Nala of Ido Pukuri Tea Estate, Houston. In his testimony, PW3 deposed that as he was the VDB secretary, people informed him that one dead body was found in a drain at their one dead body of a female was found in a drain of their tea estate. So accordingly, he informed the police. On receipt of the application from PW3, the officer in charge, Sonari police station registered a case being UD case numbers 27/2008. Full stop. The investigation of UD case number 27/2008 was entrusted to PW1. Full stop. On being so entrusted, PW 21 they proceeded to the place of occurrence, that is the drain at Idapuguri Tree Estate. Full stop. Going there, PW found a dead body in a drain. And he noticed that the lower part of the body was in a decomposed state. Full stop. Para. Waiting impossible. After recovering the dead body from the drain, inquest proceeding was conducted at section 06 of the Idapuguri Tea Estate itself by an executive magistrate, Soraidev, in reference to Sonari Police Station UD case number 27/2008. Full stop. After conducting the inquest proceeding, an inquest report within
Also, may I
bracket,
take a leave for a few minutes?
within bracket EXTP-3 was prepared, wherein it was internally recorded that the dead body was found swollen with white colored worm found in the whole body. Full stop. It was reported that skull of the head was with no skin and flesh. Full stop. In the right forearm of the deceased, there was a tattoo, quote unquote, Sri Krishna. And in the left forearm, there was another tattoo, quote unquote, Sanjeev. Full stop. It was further recorded that no external injury could be traced. Full stop. To find out about the actual cause of the disease, the death of the deceased, the executive magistrate Sonari advised the officer in charge, Punari Police Station, to take the dead body to the nearest civil hospital for post-mortem examination. Stop. Para. A sketch map of the place of occurrence was prepared by the IO PW 21 as EXTP-6. Postmortem examination report. 2:30. The dead body so recovered was dispatched to Hibahagor Police Station on 29/8/2008 in reference to Sonari Police Station, UD case number 27 of 2008. Postal. The postmortem examination on the dead body of the deceased was performed on 29/8/2008 by Dr. Budhin Soikia, Senior Medical and Health Officer, Shibohagar Civil Hospital, within bracket PW 19. In his testimony, PW 19 deposed that after conducting the postmortem examination on the dead body of the unknown female, he found the following, which he recorded. He recorded the following findings in the postmortem examination report within bracket PXT 51555. Is particular. In the PME report within bracket EXT 5, the autopsy doctor, PW 9 had further recorded that the dead body of the female was decomposed with full of maggots. Full stop. The dead body had exposed skull bones, and facial bones. Full stop. No incisors and premolars teeth from both jaws could be seen, and the uterus was absent. Full stop. PW 19 testified that the viscera within the stomach was preserved in one bottle, and kidney and liver were preserved in another bottle. Full stop. In the PME report within bracket EXT 5, he opined that the cause of death could not be ascertained, and therefore, the viscera was sent for forensic examination to ascertain the cause of death. That's all. We can get us. Get us. And few percent, just a minute. Give me the plus. See what I say. Mega, whatever, mega, whatever. Huh? Right, right. Right about me. Sequence of events of placement. Itu kan ada teman. Ada semua seperti itu ada. Saya ikut dia. Kasi 258. Kunek ko kuna sila. Isa to ay kunek ko. Number coin again. Who is the FSL expert? This is FSL report is exhibit 16, 258.
Exhibit.
Somebody exhibited perhaps, no? Huh? Exhibited P16, P21. P21. Ah. Seven, puzzle. Seven, puzzle. P20 English. When 258 what? This is a P16 or P16. The Vishera, the two bottles. Bottle postmortem. Okay, doctor. Two bottles where the viscera stomach and kidney, Roman, and liver were reserved by the autopsy doctor, was forwarded by the IO to the Forensic Science Laboratory, FSL, at Guwahati. for examination. Full stop. After examination, comma, the Scientific Officer, Toxicology Division, FSL, Assam, forwarded his report in reference to UD case number 27/2008 to the IO, and the IO PW 21 exhibited the said FSL report as EXP-P-16. Full stop. As per the FSL report P within bracket P-16, dated 3/10/2008, comma, no poison were found either in the stomach or in the liver or in the kidney. No poison was found in stomach, comma, liver and kidney. Full stop. Para. Statement of the report. For detail. Okay, for detail. It was on 4/9/2008, comma, the Ananta Gwala lodged the FIR on receipt of which, comma, Punari Police Station case number 194 of 2008 was registered, comma, as mentioned above. Full stop. The statement of the informant, comma, Ananta Gwala within bracket PW 9 was recorded by the IO in the police station, and one color photograph of the deceased, comma, Junaki Gwala was submitted by PW9, and the same was seized by a seizure list, comma, EXTP7. Full stop. The colored photograph seized by the seizure list EXTP7 was exhibited before the court as material object number 1. Full stop. Para. During the course of investigation, comma, the IOPW1 recorded the statement of Citranjan Dasgupta by forwarding him to the Court of Planet Subdivisional Judicial Magistrate M. Soraidev at Punari on 30/10/2008. Full stop. The statement of Citranjan Dasgupta was recorded by the learned SDAGM M. Soradio on 30/10/2008, and a said statement was exhibited as EXT P-8 by the IO PW 21. Posto. A sketch map of the PO of the house of the deceased was prepared and exhibited as EXTP9. Posto. Para. The IO PW 21 testified that after interrogating the witnesses and during the course of investigation, he found that the deceased, Junaki Goala, used to work in the house of the accused, A1. And he also found involvement of the accused, A1 in the incident. Pusto. The accused, A1 was apprehended by the IO on 5/9/2008. Pusto. When he interrogated the accused, A1, the accused, A1, disclosed about the involvement of the present two appellants, A2 and A3. Full stop. It was IO PW 21 further testified that both the present appellants, as per the accused, A1, both the present appellants assisted the accused A1 to kill the deceased, Junaki Goala. And accordingly, on 23/8/2008, the three of them hired a vehicle took a vehicle and they met Junaki Goala at a place and finally they killed Junaki Goala by tying a plastic rope around her neck. Post op. IO PW 20 and further testified that it was disclosed to him that the accused persons chewed a plastic rope inside the Jaboka tea estate, and the dead body was thrown in a drain at Aidopukuri area. Coastal. IOPW1 stated to have seized a plastic rope, which was shown by the accused, A1, and he exhibited a seizure list, EXTP-2 in that connection. Coastal. A sketch map of the area at Jaboka Bagan Tiniali was prepared, and exhibited as EXTP-10. Postopera. On 6/9/2008, at around 1 AM, in between 1 AM to 2 AM, both the present appellants were apprehended and brought to the police station. Justo. Para. In the course of investigation, one scooter Vespa, along with the relevant documents, and one Tata S vehicle, along with the relevant documents, were seized by seizure lists EXTP 11 and EXTP-3 respectively. EXTP 11. EXTP-3, EXTP and EXTP-4 respectively. Post. Para. According to the testimony of the IOPW 21, there were sufficient materials against the 3 accused persons, including the present 2 appellants, on finding. He arrested all 3 of them and forwarded them to the court on Six 9/2008. The arrest memos and the forwarding reports were exhibited as EXT P12 to EXT P15. Posted. Finally, after completing investigation into the case, finally, after going through the statement of the witnesses, the IOPW1 finding sufficient materials against the 3 accused persons, including the present appellants, the charge sheet EXT P17 was submitted. Post. Para. As mentioned by the learned counsel for the appellants. Oh, no, sorry, as mentioned. The learned trial court had found and recorded the recorded, comma, in paragraph 40 of the judgments proposal 40 of the judgments page comma the circumstances the following circumstances, comma, in chronological order, comma, to be established. Page 207. On the basis of the above circumstances, comma, the learned trial court had recorded the finding that the guilt of committing murder of Junaki Gwala pointed towards the three accused persons, comma, A1, A2, and A3, for paragraph 41. Another, the learned trial court had also found the statement of Citranjan Dasgupta, within bracket, not a prosecution witness, not a witness in the trial, recorded under section 164 CRPC and exhibited as EXCP this as relevant and found admissible in evidence as the prosecution has proved that the said witness has expired, and the said fact would be admissible under section 104 of the Evidence Act. Full stop. It is not in dispute and also testified by the IO PW 21 that Sitaranjan Das আয়ুর করছিল না? All right. As testified by the court witness, comma, CW1, that Sitaranjan Dasgupta passed away on 17/11/2011. Right? Page 58. Hmm? Ayo. Lo sabía. Lo sabía. Hmm. Post. The Land Trial Court has proceeded to place if proceeded to accept the statement, comma, EXCP8 as relevant and admissible on the basis of Section 33 of the Evidence Act. Post. Statement to put it. Statement to put it. Good. Before entering into any discussion as regards the relevancy and admissibility of the statement of Sitaranjan Dasgupta, within brackets, since this is and not a witness. We have looked into the contents of the same. Upon perusal, comma, we found that in the said statement, there is no whisper, no allegation, no whisper, not to speak of any allegation, comma, against the present two appellants. Right, Ms. Mia? Those now. PW, no, EXTP8, page 239. Is there anything about the two appellants?
Talks about only this one.
Talks about Sanjeev.
Sanjeev.
So that is, I have recorded absolutely no whisper, not to speak of any allegation. Till 2013. 33. Full stop. In the above view of the matter, comma, it is apposite to find out whether there can be any relevancy and relevancy of the said statement, comma, EXTP-8, and as to whether the said statement, comma, EXTP-8 can be admitted into evidence on the basis of the rule of evidence embedded in Section 33 of the Evidence Act. Full stop. Section 33 of the Evidence Act reads as under. Para. Under section 33 of the Evidence Act, evidence given by witness in a judicial proceeding or before any person authorized to take evidence, authorized to take it, is admissible for the purpose of proving in a subsequent proceeding or in a later stage of the same proceeding, comma, the truth of the facts which it stated in its evidence given in earlier judicial proceeding or earlier stage of the same judicial proceeding, semicolon. But under proviso, but under the proviso to section 33, there are three prerequisites for making the said evidence admissible in subsequent proceeding or later stage of the same proceeding, and they are yes. The explanation to section 33 states that a criminal trial or inquiry shall be deemed to be a proceeding between the prosecutor and the accused within the meaning of section 33. Full stop.
Like a principle of res judicata, man. More or less. If it is the whole.
The true reading, from the provision of section 33 of the Evidence Act, comma, as per, one of the essential prerequisite is that the adverse party must have had both the right and the opportunity of cross-examining the said witness. Full stop. Mayor. Full stop. The statement at the stage of recording the statement, comma, EXTP8, comma, the defense neither had the right nor had the opportunity to cross-examine the person named Cittaranjan Dasgupta, who subsequently died. Full stop. The provisions of sections 164 CRPC, the recording of the statement of a person under section 164 CRPC is at the stage of investigation, and the provisions of CRPC, provisions of 164 CRPC, provisions of the 164 CRPC does not provide any right or opportunity to an accused to cross-examine the witness. So therefore, comma, the finding of the learned trial court regarding the relevancy of the statement, comma, EXTP-8 is not acceptable. Full stop. As the appellant's hearing neither had the right nor had the opportunity to cross-examine the person named Citranjan Dasgupta, who later on expired, comma, the statement exhibited by the prosecution as EXTP-8 cannot be read into evidence as it is inadmissible in law. Correct? Correct me if I'm wrong.
And moreover, it is not a substantive evidence.
No, it is not, but if he has read into it, the
Yeah.
story, because he has read the whole story from Citranjan Dasgupta.
Yeah,
And I also read the whole story from Citranjan Dasgupta. So this has to be dealt with,
yes,
right?
yeah, no, also very correct.
Now we come to the circumstance. Para. It is now time to have a look at the testimony of the other prosecution witnesses. Post up. Para. PW1. Though knew the deceased and the accused, comma, A1, comma, did not know the informant. And present to appellants. As regards the incident of death of Junaki Gwala, PW1 stated that he did not know about the incident. Para. PW2 knew the deceased and two of the accused persons, but did not know the informant. PW2 did not depose anything relevant about the incident. Para. एक सीधा witness person. PDB. PW3. A reference about about PW3. It was on the basis of the information provided by PW3, the then PDB secretary, comma, UD case number ইমান আছে যে এইটো ইডি কেছ নাম্বাৰতে আছে ইডি কেছ নাম্বাৰ হোৱা নাই কিন্তু মেনশ্যন কৰি থৈছে নেকি 27/2008 was registered on 29/8/2008. Post of. In his testimony, PW, she stated that after his information to police, police personnel came and found the dead body of the female. Post of. As regards the accused persons committing the murder, PW3's testimony was hearsay. Post of. PW3 stated that he did not see the dead body from closely. Post of. Though, what is the seizure, Mr. Kotoki?
Caesar is there, my friend.
Because you said something about seizure,
Caesar, yes.
that he was not shown.
His name
Rope
is Warrant
something,
P-
rope,
219, my lord.
219.
Yes. That page 219, that is the Caesar list, my lord. The rope, man. The warrant RDPW3, my lord,
Ah.
220, my signature is there.
690.
But it was proved by PW10.
Ah.
That is Montu.
Montu, the other one.
Other one.
Ah.
And your lordship.
Though the seizure list, EXT, P-2 seizure list, MR number 130, 2008, whereby one plastic rope of about 2 meter length was shown to be seized with PW3 as a seizure witness, as one of the two seizure witnesses, the said seizure list, EXTP2 was not exhibited through PW3. One software seized on 6/9/2008. Very even here, say, and what will you have did, I can go to question. PW4 did not know the informant. Post stop. As regards the incident of death of Junaki Gwala, his testimony was hearsay in nature, and he clearly stated that he did not have any personal knowledge. Post stop para. PW5 knew the informant and two of the accused persons apart from the deceased. PW5 stated that he knew that the deceased used to work at the house of the accused, A1, and A1 was a teacher. Post stop. Regarding illicit relationship of the deceased with the accused, A1, the testimony of PW5 was hearsay. Was the PW5 further stated that he heard that the dead body of the disease was traced out at a culvert of Ideopukuri tea estate. And later on, he heard that the accused persons killed her. Full stop. He further stated that he did not go out to see the dead body. As he did not go to the place of occurrence. Full stop. He further stated that he came to know about the incident from the television news. Full stop. Para. PW6 was a reporter of the newspaper, Doinik Janambhumi. Full stop. Having heard about the incident, he went to the police station. Full stop. PW6 stated that at the police station, he heard that the officer in charge interrogated the accused persons, and the accused persons confessed their guilt. He further heard that the accused persons conspired to kill the deceased and kept her dead body at Ideopukuri tea estate. Full stop. He admitted that he did not know how and when the incident occurred, and he did not talk to the accused persons. Full stop. Para. PW7 was another reporter who worked for the newspaper Amar Assam. Full stop. Like PW6, PW7, having heard about the news, also went to the police station. Going there, full stop. Going there, he found that the accused, A1, confessed that he murdered the deceased, who used to work at his house. As regards the alleged relationship, PW7's testimony was hearsay in nature. Full stop. PW7 further stated that he knew about the incident only from police and did not know since when the disease was absent. Full stop. Para. PW, the person named Ankit Kurmi was examined by the prosecution on 2 occasions as PW8 and PW11 on 30/03/2021 and 02/01/2023. On both the occasions, PW Ankit Kurmi as PW8 and PW11 testified that he had no knowledge about the incident and he did not know. He neither knew the informant, nor the disease, nor the accused persons. PW9 was the informant and the son of the deceased. Full stop. In his evidence in chief, PW9 deposed that the incident took place in the year 2008, and at that time, his mother used to work in the house of the accused, A1. Full stop. He heard that his mother had an affair with the accused, A1. And A1 used to take his mother with him whenever he went outside. Full stop. PW9 stated that one day A1 took his mother to Guwahati along with him. Full stop. As his mother did not return home, even after one day, he went to the house of A1, searching for his mother. Full stop. Then, A1 told him that he had not taken his mother anywhere with him. Full stop. PW9 further stated that a person named Niranjan Das, within bracket, not a witness, within bracket, not a witness, told him that his mother told Niranjan Das that A1 had threatened her with death. Oh, full stop. PW9 further stated that Niranjan Das had expired. And as he failed to trace his mother, he lost the affair. So it was after 3 days of lodging the affair, the dead body of the deceased, dead body of his mother, was found under the culvert at Aido Pukuri. But, he could not see the mother's dead body. Because it was not there actually, already disposed of. PW9 further stated that his maternal uncle Subhan Wala, within bracket PW20, identified the dead body. Full stop. And that PW9 further stated that at the time of the incident, he was a student of class 5. Full stop. He exhibited the FIR, as EXTP1. Full stop. During cross-examination, PW9 stated that he lost the FIR after recovery of the dead body. And his mother had gone to Guwahati 4 days before her dead body was recovered. Full stop. He and his mother were the only members in their family. At the time of leaving, his mother told him that she was going to Guwahati with A1. Full stop. PW9 stated that he lost the affair on the advice of Niranjan Das, within bracket since disease. And subsequently, he came to know that A1 had killed his mother. Which he mentioned in the affair as he suspected A1 to have killed his mother, parent. PW9 Mintu Gogoi 10 did not know the informant the disease and the accused persons. Postal. In his evidence in chief, PW10 stated that on a particular day, he saw a gathering beside a drain near Ideo Pukuri Tea Estate. Seeing the gathering, he went there and saw a dead body of a woman lying there. PW10 stated that the dead body was not in a condition to be identified. And he noticed a pair of chandels lying beside the dead body. The police found a plastic rope at the said spot. PW10 stated that the police seized the pair of sandals and took his signature in the seizure list, EXT P2, and he identified this signature in EXT P-2 as EXT P2 within bracket 1. PW10 also stated that his signature was taken in the inquest report EXTP3 and he identified his signature therein as EXTP-31. In cross-examination, PW10 stated that the police personnel were present when he went to the place of occurrence. And he did not know where from the police had brought the rope. It is relevant to notice that the seizure list EXTP2 within bracket MR number 130/2008 was shown to have been prepared on 6/9/2008, wherein PW10 has been shown as one of the two seizure witnesses. PW11 did not know the informant, the disease and the accused persons, and did not know anything about the incident. PW10. Was a reporter of the television channel, Newsline at the relevant time. In his testimony, PW12 stated that he did not know the informant and the accused persons. But hearing the news that a woman was murdered, he went to the police station and he found that at the police station, comma, three persons were kept apprehended. And they admitted that they had caused the murder and threw the dead body into a drain at Aidapukuri. Post of PW 12. Bolded quit also. Stated that the police took them to Aidapukuri tea estate, where the accused persons showed them the dead body in a drain, and the police recovered the dead body and took their statements. Post of. During cross-examination, comma, PW 12 stated that they recorded video but did not hand over the data to police. Post of. He admitted that they were not present there when the police interrogated the accused persons, and he had deposed on the basis what A1 stated before the police in their presence. Full stop. Para. PW9 was another journalist who neither knew the informant and the accused persons. Full stop. As regards, sorry, 13. As regards the incidents which occurred in the year 2008, comma, he stated that on receipt of information that from the police station that a murder had taken place, he, along with 4 or 5 other reporters, went to the police station. Full stop. At the police station, comma, they found A1 confessing to have committed the murder before the police, and they recorded the same through their cameras. A1 stated that he committed the murder with the help of A2 and A3, and thereafter threw the dead body into Aidapukuri tea estate. Full stop. PW 13 stated he did not go at the time of recovery of the dead body, and the dead body was recovered by police with the help of the BDP. During cross-examination, comma, he stated that he did not record anything with camera and denied a suggestion that the accused did not confess his guilt in his presence. Full stop. PW 14 stated that he was an ambulance driver and he used to drive ambulance in 2008. Full stop. PW 14 stated that he did not know about anything about the incident. Full stop. And police did not question him. Full stop. The prosecution thereafter declared PW4 as a hostile one and sought permission from the court to cross-examine PW14. During cross-examination of PW14 by the prosecution, comma, PW14 denied to have made statements which the prosecution had claimed to have been made by PW 14. In his statement recorded under section 161. The prosecution had, however, did not bring the statement of any statement of PW 14, any previous statement of PW 14 recorded during the stage of investigation. Close to. During cross-examination by the defense, PW 14 stated that police did not meet him in connection with the incident. And he did not know anything about the murder case. Mr. Kotogi will rise because my esteemed sister has 2 other matters in the single bench. Tomorrow at 2. Let him prepare. Heard Mr. Kotogi be here. Place the case tomorrow. As part of the case will be taken up at 2 p.m. Anything incorrect I dictated?
One NETV reporter, your lordship, News Live or something like.
Okay, it is there. He said
Yes,
in News
yes.
Live.
News live, news live.
News Live. Huh? I found News Live. Which one? Which one?
12. and
12.
Camera person any time. Please 32. Page 32 cross-examined person.
I think he promoted his reporter of News Live. Okay, NETV. Okay, NETV leave. At the, was the reporter, was the cameraman of the TV channel NETV at the relevant time.
At the relevant time.
After that, he became News Live.
Yeah, at the time of deposition, he become.